Let's talk about planning for LGBTQ plus couples. With the Supreme Court's recent overturning of Roe v. Wade, it puts the case Obergefell, which allowed same-sex couples to be married, at risk. We don't know what the Supreme Court's going to do, but the fact that they have decided not to follow precedent of the court means that a number of civil rights that were sort of decided with the same undergirdings as Roe v. Wade might possibly be overturned. Certainly there are efforts being made to do that. Proactive estate planning for same-sex couples is really important in this sort of unstable environment. In fact, estate planning can mimic many of the benefits of marriage between same-sex couples. Let's say that you're a couple but you're not married and you've been living together for a long time, and let's say neither you nor your partner have a will. If something happens to one of you without a will, all of your assets will go to your closest relative. So that means assets will pass by intestate succession. That's a legal term that means your closest relative. If you've been with somebody for a long time, your closest blood relative may not be the person you want your assets to go to. Perhaps even more important is incapacity planning. If you become incapacitated and you're unable to handle your own legal or financial affairs or unable to make healthcare decisions, if you don't have a power of attorney or a medical power of attorney naming your partner as your agent for the power of attorney or medical power of attorney, then your partner's not going to be able to make decisions for you or handle things when something happens to you. And if your biological family doesn't approve of your lifestyle, your partner may very well be shut out of even being nearby you while you're suffering from the incapacity. Also, a HIPAA release is important. A HIPAA release allows doctors to speak to people that you name about your medical care and medical condition. It's important to have your partner on one of those as well. If you are married and you both have a will but no trust, you might want to consider getting a trust. A will has to go through the court process called probate, which is how assets are retitled if you die with a will or without a will. You can avoid the probate court by having a trust. And one of the reasons to avoid the probate court is if you have family members that might contest a will. You can't do that as easily with a trust. Another way that estate planning can really help same-sex couples is with guardianship. If something happens to the biological parent, the non-biological parent, if they haven't adopted the child, might not be able to have custody of the child. A family member might step forward and you just don't know what a judge is going to do in that regard. So it's really important for same-sex couples to have a kids protection plan, which allows you both to name long-term guardians and short-term guardians, folks that could respond in an emergency, but also to name people that you would never want to act as guardian for your children. I really wish that things weren't so unsettled in the law with people's civil rights right now, but the reality is that they are, and estate planning is one way to help make things more certain. If you want to talk more about planning for same-sex couples, give me a call.